Let's start. It is submitted by Mr. Dotto, learned senior counsel on behalf of the petitioner that on the basis of oral undertaking given by the learned special public prosecutor on behalf of the opposite party, the Enforcement Directorate did not find any necessity to pray for issuance of production warrant against the petitioner. The petitioner also relied on such oral undertaking in support of his contention. He refers to a report published in an online news portal under the name of Live Law, where it was reported that the Enforcement Directorate gave an oral assurance to the Delhi High Court that it will not execute production warrant till January 9 against A. Mondal. It is also submitted with reference to the order dated 2nd February 2023 passed in CRL MC 7014/2022 and CRLMA number 27148/2022 that the Enforcement Directorate prayed for time before the Delhi High Court to file status report in connection with the case under PMLA against the petitioner, but the said status report has not been filed as yet. Mr. Dotto next takes me to Annexure P/9, being an application filed on behalf of the petitioner for suspension of the order dated 2nd March 2023 passed by the learned special judge CBI at Asansol in CBI case number 01/2021 and especially draws my attention to paragraph 4.1 and paragraph 4.6. It is contended on behalf of the petitioner that the production warrant dated 20th December 2022 in a subject matter of challenge before the High Court of Delhi in CRLMC 7014/2022, wherein the learned special public prosecutor on behalf of the Enforcement Directorate gave oral assurance that the production warrant against the petitioner issued by the trial court at Delhi would not be executed, and the said assurance is still in force. It was also contended on behalf of the petitioner that the petitioner was not served with a copy of the application filed by the Superintendent, Asansol District Correctional Home on 2nd March 2023 para. But it mentioned here that on 1st March 2023 the Superintendent Asansol Correctional Home received an email from the Additional Directorate HIU New Delhi directing him to produce the petitioner in the trial court at Delhi in connection with the above mentioned case under PMLA. The learned judge special court CBI Asansol allowed the prayer made by the Superintendent of the Correctional Home directing him to cause production of the petitioner before the learned special judge within bracket PC Act CBI 18 at Rouse Avenue Court, New Delhi. Objection filed by the petitioner was subsequently rejected by the learned judge at Asansol para. It is vehemently urged by Mr. Dotto that the writ petition filed by the petitioner challenging jurisdiction of the trial court at Delhi is pending and has been fixed now on 17th March 2023. The learned special judge Rouse Avenue Court has also not decided the issuance relating to jurisdiction as per the direction made by the High Court at Delhi on 15th December 2022 as yet. Without deciding the said issue, the petitioner cannot be directed to be produced before the trial court at Delhi. Next limb of the argument advanced by Mr. Dotto on behalf of the petitioner that the petitioner is seriously ill. He was shifted to hospital yesterday and at this stage on health ground he should not be taken to Delhi. It is submitted by Mr. Dotto that section 269 of the Code of Criminal Procedure empowers the officer in charge of the prison to abstain from carrying out the court's order under section 267 of the CRPC, where the person in respect of whom an order is made under section 267 of the CRPC is by reason of sickness or infirmity unfit to be removed from the prison. Para. Mr. B. Bhattacharya, learned Deputy Solicitor General, on the other hand, submits that the instant application filed by the petitioner is liable to be dismissed summarily on the ground of suppression of materials, fact, and conscious but utterly illegitimate attempt of forum shopping at the outset. It is submitted by the learned Deputy Solicitor General that the petitioner did not annex the order dated 19th December 2022 passed by the learned Special Judge Rouse Avenue Court, Delhi. He submits a compilation containing the copy of the said order dated 19th December 2022. The learned trial judge, by an elaborate order, allowed the application filed by the ED under section 267 of the CRPC read with section 65 of the PMLA by filing an application under section 482 of the Code of Criminal Procedure before the High Court at Delhi on 2nd March 2023. The petitioner prayed for para. Necessary orders and directions, thereby the oral statement made by the respondent within bracket ED by made a part of a written order, and that the production warrants issued by the impugned order dated 19/12/2022 passed by the learned Special Judge Rouse Avenue Court, Delhi, allowing the application under section 267 CRPC R/W section 65 PMLA 2002 filed by the respondent within bracket ED be ordered to be stayed till the next date of hearing, and pass any necessary and appropriate order and direction as the Honorable Court may deem fit and proper in the facts and circumstances of the case. Para. Mr. Bhattacharya further draws my attention to paragraph 14 of the aforesaid application and submits that paragraph 14 of the instant application is same and identical. In the instant application, the petitioner has assailed the order dated 2nd March 2023 passed by the learned Special Judge Asansol in Special CBI case number 1 of 2021 and pending disposal of the application placed for stay of operation of the said order. It is contended by the learned Deputy Solicitor General that the purpose and purport of both the applications are similar, that is to stall execution of production warrant. Para. Mr. Bhattacharya further submits under instruction that Mr. Ankur Chawla, learned advocate for the petitioner, yesterday undertook at Delhi High Court that the petitioner would not place the present application on such condition. The Honorable Bench of Delhi High Court heard the application filed by the petitioner but refused to pass any interim order of stay. As soon as the petitioner failed to achieve favorable order, the instant application has been moved, suppressing the undertaking given by the learned advocate for the petitioner yesterday at Delhi High Court. Para. According to Mr. Bhattacharya, the above act by the petitioner is a clear instance of suppression of fact and forum shopping. The attempt made by the petitioner should be taken very harshly, and exemplary cost should be imposed against the petitioner. In support of this contention, Mr. Bhattacharya refers to a decision of the Honorable Supreme Court in the case of Bombay Metropolitan Region Development Authority, Bombay versus Gokak Patel Bholkat Limited and others, reported in within bracket 1995 1 SCC 4642, referring to paragraph 12 and 13 of the aforesaid report. It is submitted by Mr. Bhattacharya that the petitioner had already approached the Delhi High Court under section 482 of the Code of Criminal Procedure for staying operation of the order dated 19th December 2022 passed by the trial court, and having been failed, he moves the instant application for the same relief in roundabout way, which is not permissible under the law. Para. On the issue of forum shopping, learned Deputy Solicitor General relies on Kamini Jaiswal versus Union of India and Another within 2018 1 SCC. It is observed by the Honorable Supreme Court in the above report, forum shopping takes several hues and shades, even making allegations of a per se conflict of interest and requiring transfer of matter to another bench has been held to be a form of forum hunting. A classic example of forum shopping is when a litigant approaches one court for relief but does not get the desired relief and then approaches another court for the same relief. Jurisdiction in a court is not attracted by the operation or creation of fortuitous circumstances. To allow the assumption of jurisdiction in created circumstances would only result in encouraging forum shopping. Another form of forum shopping is taking advantage of a view held by a particular high court in contrast to a different view held by another high court. This could not be allowed, and circumstances such as this would lead to some sort of judicial anarchy. Successive bail applications filed by a litigant ought to be heard by the same judge, otherwise an unscrupulous litigant would go on filing bail applications before different judges until a favorable order is obtained. Unless this practice was nipped in the bud, it would encourage unscrupulous litigants and encourage them to entertain the idea that they can indulge in forum shopping, which has no sanction in law and certainly no sanctity. Another category of forum shopping is approaching different courts for the same relief by making a minor change in the prayer clause of the petition. Similarly, substituting some petitioner for others with a view to confer jurisdiction on a particular court would also amount to forum shopping by the group of petitioners. Another form of forum shopping is where a litigant makes allegations of a perceived conflict of interest against a judge, requiring the judge to rescue from the proceedings so that the matter could be transferred to another judge. Stop. Thank you. Jai Hind. Jai Mera Bharat. Substituting some petitioner for others with a view to confer jurisdiction on a particular court would also amount to forum shopping by the group of petitioners. Another form of forum shopping is where a litigant makes allegations of a perceived conflict of interest against a judge, requiring the judge to rescue from the proceedings so that the matter could be transferred to another judge. Stop. Thank you. Jai Hind. Jai Mera Bharat.